Today I am going to teach you topic 1 of the company law, nature and kinds of the companies under Companies Act 2013. A company meaning association of individuals and formed for the purpose of some business. It is defined under section 2 subpart 20, and a company formed and registered under the Companies Act 2013 or any previous company law. The advantages on nature and characteristics of the companies are that independent corporate existence, independent legal person, different from members and shareholders and subscribers, distinct person and distinct entity. Limited liability. The companies have a limited liability and the number of liability only of their share, 100 shares of 10 rupees each, and the member paid rupees 5 for each share. Remaining money would be 500 rupees and the liability for rupees 500 only will exist. Company's liability is unlimited and liable to pay as long as the assets are available. The perpetual succession means that members may come and members may go, but the company can go forever. Death and insolvency of the individual members not affect its existence, continuance in existence until it wounds up. Transferability of shares. Members can sell their shares and get the amount of their investment and get the relief of the liability. B. It ensures the stability of a company, provides for the liquidity to investors. Separate property. Property of a company vested in corporate body. Company can hold and enjoy the property. No member and not even all members can claim the ownership of the company. Legal persons can sue or can be sued in its corporate name. Disadvantages of the companies are formalities and expenses. Incorporation is expensive and too many formalities to be complied for the formation and the administration. Company is not a citizen, legal person but not a citizen, and has only such fundamental rights and which are for every person, citizens or not. C. Have nationality and domicile and residence. D. Company incorporated in particular country has nationality of that country and cannot change the nationality like nature person. Lifting up of a corporate will means where a fraudulent and dishonest use is made of the legal entity and the individual concerned will not be allowed to take the shelter behind the veil of the corporate personality. The court will create through the corporate shell and apply for the principle of doctrine and what is called a lifting of the piercing of the corporate veil. The Companies Act 2013 contains the provision under section 7 subpart 7 of the and section 251 subpart 1 of the and section 339 which lift the corporate veil and reach the real culprits. There are several cases where the courts have lifted the corporate veil to a certain grounds such as fraudulent or improper conduct. Case Jonas versus Lipman. Lipman was the company owner and it sold it to the Jonas, and Lipman entered into a contract with Jonas to sell the certain property to Jonas. Later, the Lipman fraudulently sold his proprietorship to his company. Jonas filed a case against the Lipman whether an order of specific performance could be enforced in the circumstances. It was found that the defendant company was created by the defendant as a mask to avoid the recognition by the I equity, and on the basis of the Lipman was ordered to perform the agreement. It means there was a specific performance of the contract by the court. Company is a cloak and sham. Second case is Guilford Motor Company Limited versus Horney. Horney was an employee in a Guilford Motor and appointed as a managing director. Horney has signed an agreement that he, while in office or afterward, will not solicit a entice customer and company. Means he will not solicit any of the personal customer of the company after leaving the job. Horney employment terminated under the agreement. Horney started a new company and solicited plaintiff customers. Issue same as Jonas and Lipman. Judgment. The court in its judgment described the company as a device, as mere a cloak or sham for the purpose of enabling the defendant to convict a breach of his agreement with the plaintiff. The court held that the company was a sham and granted an injunction against his companies as well. him. Evasion of tax avoiding welfare legislation related to the Workman versus Associated Rubber Industry Limited. Fact says that the company created as a subsidiary and transferred its investment holding to it in a bid to reduce its liability to pay the bonus to the workers. The subsidiary company had no assets of its own except those transferred by the principal company. The subsidiary company received the dividends from the transferred shares and served the no purpose except to reduce the profits of the principal company. Issue whether the principal company and subsidiary company are two legal entities separate. Judgment. Supreme Court brushed aside the separate existence of the subsidiary company for the purpose of calculating bonuses payable to the workman. Declared to the workmen are entitled to be paid bonuses. Determination of the enemy character. Case Daimler Company Limited versus Continental Tire and Rubber Company Limited. It is related to alien enemy. All except one of the Continental Tire and Rubber Company Limited shares were held by the German resident, which was an alien company. All directors were Germans and resident. The secretary was English, means Britain. During World War I, the company filed a suit in an English court to recover the trade debts. It was pleaded before the court that the company belonged to the alien enemies and therefore it should be restrained from recovering the trade debts. Whether the company was an alien company and that payment of the debt would be trading with the enemy. The House of the Lords held that the company, through incorporated in United Kingdom, was an enemy company and its real character was a German. Therefore, the company was not allowed to proceed with the actions recover its trade debts. To calculate the true nature of the transaction. Case Subhra Mukherjee versus Bharat Coking Limited, Coal Limited. Whether the transaction in question is bona fide and genuine, the Supreme Court ruled that the transaction was not bona fide and the transaction was a sham and collusive, and it was brought into existence to avoid the effect of takeover of the property by the central government consequent to the nationalization of coal mines. Oh, thank you.